Shautsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you about prosecutorial discretion and what changes came with the change of the administration, presidential administration. During the Obama administration, DHS issued several memos detailing which classes of respondents would qualify for something called prosecutorial discretion and which classes should apply. What basically was going on is that because the immigration system, immigration court system is so overwhelmed with amount of cases that they need to decide and put through the system, and because many people have long time family connections in the United States, and some of the people will be able to qualify for relief, but maybe not at this time, but at a later time. And some people have different circumstances, like minor children, and maybe some health conditions. Obama administration decided that it would be beneficial for everyone if some of those classes of respondents or people who are in immigration proceedings will be allowed to stay in the United States and wait until they would qualify for some sort of relief or the situation would change. Basically, that whole plan was known as the prosecutorial discretion. And what was happening in courts during that time is that if, let's say, a person would come in and the government would estimate his or her chances of removal and take into consideration favorable factors, the government attorney decides that the person would qualify for favorable discretion. Such a person's proceedings would be either terminated, administratively closed, or maybe an order of removal will be issued, but the person would be still allowed to stay in the United States on something called order of supervision. I personally had a number of clients who qualified for this relief, and it seemed to work. With the Trump administration would like to physically deport everybody that they can. As a result, they abrogated the previous memos that would help classes of respondents to qualify and apply for prosecutorial discretion. And according to Trump administration, now all cases should go to conclusion, basically to physical removal. This is their priority, this is their goal. However, they did confirm that prosecutorial discretion still exists, but it modified. Basically, no more classes of respondents who would qualify. Every case will be decided on a case-by-case, fact basis, meaning that they will take an individual situation and will see if the person deserves discretion or not. Another important change that came is that if, let's say, how prosecutorial discretion works. Well, basically, an attorney for a respondent, like me, for example, would go to the trial counsel, an attorney for the government during the proceedings, and ask the government to exercise prosecutorial discretion and terminate the proceedings. If the trial attorney would disagree with me and say no, before I would be able to escalate the request to the higher trial attorney, to the district office, head office it's called. Now the Trump administration stated that that practice would be abolished, no more sending emails to the higher attorneys. Your trial attorney is your last resort. So this is a big change, because I can imagine that trial attorney would have his or her bias against the respondent at some point and would not want to, and if this would be on a way of granting a prosecutorial discretion, the person pretty much would be stuck with a decision and would not be able to do anything about that. Of course, there are other avenues and possibilities of appeal, maybe, or applications for administrative stay of removal. Somebody may be able to appeal to the Board of Immigration Appeals, but it's always, I believe that if you can resolve a problem on the lowest level, without spending resources and time to go up, that's always beneficial for everyone. People who are seeking to stay in the United States, and the government who does not have to spend their resources on immigration court system, Board of Immigration Appeals, or federal courts, and can allocate resources to more important things. But that's just my opinion. So those are the changes that we have now in connection with the prosecutorial discretion. It's still available. It's harder to get. The procedure is a little bit different. The the memos and requests that I filed after the Trump administration came to power, I'll be honest with you, I still use the same factors and explain the same, how the respondent uses this, meets the same criteria, just don't cite the memo. Basically what happened is that the government says don't cite the memo anymore. That was in effect during the Obama administration, but they will look at the same, pretty much the same factors, and will take the same factors into consideration, like long time ties with the community in the United States, presence of family members who are U.S. citizens or lawful permanent residents, absence or existence of criminal convictions, criminal charges, and arrests, things like that. That's what we and hardships, of course, hardships to the family members who are legal in the United States. Those are the main factors that we detail in our applications for prosecutorial discretion. And of course, probability of relief. Let's say we ask that the government closes proceedings against someone because that person now has a fiance or a U.S. citizen spouse, and very soon they will be able to qualify for adjustment of status or for I-601A waiver, and they will be able to adjust or receive an immigrant visa depending on the situation. So those factors are taken into consideration when one submits and when one decides whether or not the situation favors grant of a prosecutorial discretion. Well, I hope this little video was helpful in understanding of what's happening right now with the prosecutorial discretion and what you need to argue when you're applying and trying to get prosecutorial discretion. For more information, visit our website www.shautsova.com. Thank you.